talk, and that was interesting. She knows what she wants to do, and I think she tried to stretch it as much as possible to say, I need this, I need that. She also brought one of her clients, and one of the requirements was we're not allowed to televise him, which was good because she was much better looking. If she's talked to DEF CON, she's talked to Black Hat, it's going to be a very good talk. But one of the things I'd like to request is, can any of you with active cell phones put them on vibrate or turn them off?
Thank you.
Thank you.
So I'm Jennifer Granick, and is this kind of loud for you guys back there? Okay. I'm Jennifer Granick, and I am the executive director of the Center for Internet and Society, which is a program at Stanford Law School. And it's an academic program in which we study the intersection of public interest, civil liberties, and changes in computer technology. And I teach a class there, which is a clinical class where we're able to take cases and provide people with free legal services, and it gives students an opportunity to learn how to be lawyers. I always like to think that I am seducing these Stanford Law School students who would go off into big firms and make a lot of money into going over to the other side and working in the public interest. So I like to think that I'm creating at least some kind of legion of people who will practice in this area long after I'm done and gone. But my background and the way I got into this field was that I was a criminal defense attorney, and I started representing people who were charged with computer crimes. And it was through that I became interested in how civil liberties and questions of the public interest are affected by technology. And so because of my interest in computer crimes, I've always been really interested in computer security. And my goal here today is to share with you some of the information that I have developed, or some of the things that I've been thinking about through my career in this area. So, yes. So the way, I can use PowerPoint. The way that I conceptualized this talk was I thought this will be really great, and it'll be really crowd pleasing. What I'm going to do is I'm going to do the top 10 legal questions that Black Hat attendees have. And that way, everybody will be interested in it. I'll be talking about stuff that people think is interesting and relevant, and it'll be really fun, and I don't have to come up with a topic. I'll let people come up with a topic. And so I took a little informal survey, and I figured, I can just sort of mumble something about my data set and methodology, and you guys would be happy with that. And I came up with these 10 questions, which is totally great, except for the fact that now I have 10 things I have to talk about in an hour and 15 minutes, as opposed to my usual 1 or 2 things. And so in many ways, this is the dumbest talk that I've ever given at Black Hat, because I have so much stuff that I have to cover. But in the interest of having been accurate in advertising, I am going to go through all 10 questions, and I'm going to do it in a way that is both accurate and brief, and then I'm going to try to leave as much time as possible for questions from you guys, which can either be questions for me to elaborate on things that I've said about the 10 questions I've compiled, or other issues as well. So in the interest of time, I'm not going to read to you the 10 questions that I'm going to answer, but you can see here I have them on my PowerPoint, and these are all of the 10. And it's also in your materials, hopefully, unless somebody cut them out. Okay, now normally I don't do this for those of you who've seen me speak before, but because I have so many questions that I want to go through, I'm afraid that if I allow questions on one thing, we're going to get kind of bogged down. So I'm going to ask you to try to leave questions till the end, unless you have sort of a general feeling like nobody knows what I'm talking about, in which case, please do stop me. All right, so the first topic we're going to take up today is the question of wireless and wireless use. And this is really exciting because we have new news in this area. Very recently, a man was arrested in the state of Florida for using an open wireless access point. And it was very interesting, exciting. Lots of press people were interested, and everybody I know is interested, since most of us use open wireless access points at some point or another. And everybody wants to know, well, is it illegal? Is it illegal to use wireless? Well, as with many things in this area of the law, this answer is it depends. And actually, one of my friends, when I was telling them about this talk, said, oh, you'll have no problem getting through 10 questions in an hour, 15 minutes. You just keep telling them, well, it depends. It depends. It depends. So yeah, everything depends, but let's talk about what it depends on. So the first thing about using wireless is that we have a couple of different things you can do when you're using somebody's open wireless access point. And these things are going to be treated differently under the law. So the Florida case isn't the only case that we know about. There was a case that I was involved in California where a young man was arrested for using a wireless access point. Later, the case morphed into being about something else, so those issues weren't ever really addressed in the course of that prosecution. And there was a federal prosecution of a man named Stephen Puffer out of the court in Houston, and he was acquitted following a jury trial. He had been accused of using the wireless to access files on his former employer's network, his former employer being the county of, I guess, Harris County, which is the county that Houston's in, and they got a prosecutor to be interested in that, but the jury was less interested and rejected it. So under what legal theories could wireless be bad? Well, okay, so we have a couple different ways here that you could use wireless. Let's talk first about accessing stored files on the network. Accessing somebody else's stored files on the network is prohibited under the Electronic Communications Privacy Act, and I have the text of it here for you. What I want to do now is take a little bit of time to talk about what access means and what authorization means, because these are really important concepts in the way that the law treats computer intrusions. These are both very important. So what does it mean to access a networked computer? Well, you can think about it in kind of two ways. You can think about it in a metaphorical sort of way, like, did I get into the computer? So if I ping and it sends me back some packets, and it's just sort of like a knock on the door, if we're going to use a metaphor, then I didn't really get in and get to anything that's in the computer. So there's sort of a metaphorical sense that I knocked on the door, they said, yeah, we're in here, and that's kind of it, and maybe that's not access. But there's the reality of the way that computers talk to each other, which is you send it electrons and it sends your computer back electrons, and it interacts with those communications, and you are doing something, causing something to happen inside the inner workings of the computer. And so the question is that access? And the way that the law has generally looked at it is it's read the concept of access extremely broadly. So in essence, so in other words, it's gone more with the kind of physical view as opposed to this metaphorical view. And the result of that is that almost anything you can do, almost any kind of communication you have with a networked computer is access. So in all the cases that have ever looked at the question of whether something was unauthorized access under any of these statutes that I'm going to talk about today, they always found access. It was always access. So access is something that's super easy to do. So the thing that changes access from being allowed to something that's not allowed is this concept of authorization. So we think, well, is authorization hard to get or easy to get? A lot of times people who are computer people think that authorization is a physical thing, where it has to do with the question of whether the permissions are set such that you can access information, or whether the computer is configured or the preferences are configured in such a way that you can do what it is you're doing without circumventing some kind of security measure or something like that. Maybe even if you can circumvent the security measure, the computer allowed you to do it, so it was authorized. But that's not the way the law looks at it. Here, the law takes a very cultural approach, a very more sort of social approach to the idea of what's authorization. So not only is something unauthorized if you circumvent security measures like, let's say, a password or something like that, but authorization can also be unauthorized even when there's no security measure that gets in your way. There have been cases that say that your use... I imagine that's the air conditioning. I hope so, at least. There's been cases that say that your use is unauthorized when it's in violation of a contract, for example. So if your contract says, you're not going to, let's say you leave a company and your contract says that you're not going to have anything else to do with the computers at your old employer. If you violate that contract, that's unauthorized. It's interesting because usually violations of contract aren't related to the criminal law in any way, but here's a situation where a violation of a contract is an element of the offense. So we'll talk a little bit more about that later also. Unauthorized has been found when there's an explicit warning. For example, in one of the big cases in this area, eBay versus Bidder's Edge. Bidder's Edge was a company that had a robot that would crawl through the eBay auction site and collect auction information there. And eBay didn't want Bidder's Edge to do that because eBay wants people to come to their auction site to do the auctions there. They don't want them to go to some other site and be able to comparison shop between auctions that are on Yahoo or other auction businesses. So they said to Bidder's Edge, hey, we don't want you doing this, you need to stop. And Bidder's Edge kept doing it. The court says, well, that keeping doing it, keeping sending your robot to these machines is unauthorized because they told you they didn't want you to do it. The concept of unauthorized has been read so broadly that it's something even kind of subjective. So in the case that I think is probably the most broad reading of the concept of unauthorized that we have so far is a case involving a different kind of security, which are storage containers. And in this case, a guy was working for one storage company, and he got hired by a competitor storage company. And while he was in that period of time, he was still working at his first employer, and he went on the computer and he got a copy of their customer list. And he brought that customer list with him to the new employer. And the old employer sued the new employer, saying that they had used this guy to violate the Computer Fraud and Abuse Act and gain unauthorized access to their computer system. And of course, the new employer said, hey, he had authorization. He had a password, he had a username, he had an account, he was still working there, he was allowed to have access to this information. It wasn't unauthorized. And what the court said is that at the point in time when the employee in his mind knew that he was no longer acting in the best interest of employer number one and started acting in the interest of employer two, his use was no longer authorized because he was only authorized to use the computer to help his former employer, not to help the competition. So really broad, right? And it's just a subjective sense. I know that this person wouldn't want me to be doing what I'm doing. And I have seen this when I've represented people in cases like this. The way that they prove that use is unauthorized is pretty simple. They basically trot in the person who's the system administrator or the owner of the computer that was accessed, and they say, did you ever give Mr. Defendant permission to use your computer in this way? And they go, no, I didn't, and it's case closed, and that's all they need to know. So it's very broadly read. As a result, you have to be really careful whenever accessing somebody else's computer. I can't say that without explicit permission, it's always unauthorized, but there are many circumstances where when you don't have explicit permission, you may be transgressing that line between what's allowed and what's not allowed. Okay, so with stored files, why am I saying this? It's going to become clear. It's that this we use all the time, but it's true with stored files. If you gain unauthorized access to some kind of storage facility and you get stored files, it's both a crime and something for which you can be sued. What about capturing the contents of communications that are going over the wireless network, sniffing? Also improper. There's the statute, which is under the wiretap law, which prevents people from doing that, from getting that information. I always tell my clients whenever they ask me, unencrypted communications coming over the wireless network, can I sniff those, access those? And I always say no. I think, though, that if anybody ever doesn't listen to me and I ever get one of these cases, that one of my best defenses might be a little exception in the statute. And one of the things that you'll see if you go and take a look at these statutes, and I've given you the citation here, so you can look these up in their sort of full and complicated glory yourselves, there's a rule, and then there's exceptions, and then there's exceptions to those exceptions, except that those exceptions only apply in certain cases. So we do it that way intentionally because we want you guys to need to have lawyers, and we want to make sure that, this is like a full employment act. So we keep it, that's right, we keep it busy. It's the same with computers. They don't need to be this complicated, right? All right, so definitely they don't need to be this complicated. So one of the exceptions to the statute says that it's not unlawful to access communications that are configured so as to be available, accessible to the general public. And this was an exception that was concocted for radio, right? They don't want you to get in trouble for intercepting radio signals that are going over the air. And I think the question that I would raise and the defense that I would raise is unencrypted wireless configured so as to be accessible to the general public? If so, it's not a crime because it falls under this exception. But I am definitely not recommending that anybody try to test this for me. I'm sure it'll come up soon enough without anyone here having to throw themselves on the grenade and martyr themselves to advance the law further. Okay, what about using the network? Well, the Computer Fraud and Abuse Act, which is 18 U.S.C. 1030, a statute that is one of my favorites and also one that I hate the most and I spend a lot of time with, makes it a crime to access a computer without authorization. There you see those two concepts again in operation, and either obtain information or cause damage. So it seems like maybe an access point, if you're just using it, it's not maybe a computer under the statutory definition. And if you're just using it and you're not like using up all the bandwidth or harming anything, maybe you're not causing damage and you're not obtaining any information from the computer. If you're obtaining information, you're getting it from elsewhere on the network. So maybe this statute doesn't apply at all, which is great. And that was always what I had told people, is you can use it as long as you're not using it hogging all the bandwidth or something like that, and it seems like it's pretty much okay. And then we had my case in California and this Florida case. So you've got these state laws which are more broad, if you can imagine, more broad than the federal law is. The California law, which the person who I was assisting was charged under, is, I have it up here, I'm not going to read it to you, but you can see it says, again, you have this concept of permission, right? This sort of authorization permission, which is really important. And it says, well, here you're using computer services, and it's pretty easy to say that maybe wireless is a computer service, or the wireless access point is part of a computer network. And you don't need to cause damage to break the state law, so here you have it. Same thing with the Florida law, which this gentleman was charged with. Again, it says if you without authorization access a computer network or computer system. Okay, so what's the question here that I have? So you have this whole question of authorization. We know there's access. It seems like it's a computer network. What about authorization? It's open. It's unencrypted. It's available for use. Is it unauthorized? And my concern's always been that they'll do what they always have done in these cases, which is that they'll trot in somebody who will say, hey, I never gave that guy parked in front of my house permission to use my wireless network to check his email or download songs from Kazaa or whatever it is. And so then you have the element that it's not authorized and you're done. But I think that, and you'll notice that neither of these statutes say this, but I have argued that you need to prove, that the government would need to prove not only that you knew you were using it and that the use was without permission, but that you know it's without permission before it can be a crime. And why do I say that? Well, there's this long-standing principle in the law, and particularly in the criminal law, that you can't accidentally break the law. You don't have to know what the law is, but you can't accidentally fall on one line or the other. They want you to at least know that you're doing the acts that constitute the crime, in the vast majority of cases. And if you don't know that it's unauthorized, then you don't know that you're doing a crime, because this authorization is the trigger. It's the thing that changes legal to illegal and illegal back to legal. It's all the question of authorization. So I've argued that you'll need to know. They need to prove that you know that it's unauthorized. Now, how do they prove that you know it's unauthorized? Because people always ask this, like, how do you prove what's in somebody's mind, and how do you prove intent, and isn't it really hard without hooking people up to electrodes and kind of doing some mirroring thing where we can read your mind? And soon enough we'll come to that. And there are people now who have developed some scientific techniques where they can read little facial tics in your muscles, which are kind of involuntary little motions that belie what you're really thinking in your mind. So I'm not saying we're necessarily all that far away, but it's never really been actually that much of a problem for that to be proven, because you look to circumstantial evidence. You look to the things that were happening at the time that the person was doing the acts that would constitute the offense, and see if it shows that they maybe knew that what they were doing was wrong or without permission. So this can be, again, very cultural and subjective. If somebody's parked in their car out in front of a house with their laptop using this wireless network, does that mean they knew they had permission or they knew they didn't have permission? I think for many of us in this room, and certainly for me, I would think, people left their network open, they probably don't care if their neighbors or other people use it so long as they're not using it for any kind of nefarious purpose or for something that's going to interfere with my use. So it's probably, basically okay. But another person, maybe who doesn't use wireless all the time, who comes along and looks at that and it's like it's night, they're hiding in their car, they're sort of like, when the police came, maybe they closed their laptop and started to drive away real fast or something like that, which is a reaction a lot of innocent people sometimes have to the police. And they can use this to kind of create these circumstances in which you have this idea that the person had some sense that what he was doing was wrong. And you can think about, the last time that maybe, somebody was doing something wrong, and how could you tell? They lied about it, or they did something kind of furtive, or they, all these things which, come out as evidence of proving what somebody's intent or thoughts were at the time. Okay, so just to sum up this, is it illegal to use wireless? I used to say, well, using it without interfering with the network is fine, but we do have these state laws which appear to be something that prosecutors want to apply to these circumstances. And this is something that we have to be careful about. I can tell you, for those of you who are super risk adverse, I'm super risk adverse, and I still use my neighbor's wireless when I need to, but it's something to definitely worry about because yes, a confession, and I did it within the statute of limitations, so hopefully I'm going to be okay. But I know a lot of lawyers, so hopefully I'll be all right. But it's something to worry about, if only a few people get in trouble for it. It's definitely something to be concerned about. And, I had a case where one of the things that they looked to determine whether or not my client had a guilty state of mind or the intent to do harm or intent to do damage was the allegation that when he was arrested, he was wearing a DEF CON t-shirt. So you want to be, you want to be careful when you're looking to these social things or social signifiers that people take as evidence of having a criminal purpose or an illicit intent, because a lot of times that's going to be something that relates to, a lot of times you have to worry that that's going to be something that relates to either something that's actually not all that scary or dangerous, like going to DEF CON. And my parents and my sister are here, so they have to make sure they know it's not scary, so when they go on Saturday, it's okay. And something that's First Amendment protected, like hanging out with a certain set of people or reading certain books or wearing a t-shirt with a certain message or that kind of thing. So it's really of concern, and my feeling is that the problem is this concept of unauthorized access is not a good distinguisher. It is not a good line to draw between what's legal and what's illegal. And if I had my way, I would get rid of that concept in all these laws, and we would do it in a different way. But okay, so that's the kind of liability for using wireless. Let's talk about the liability for having the wireless be open. So now we're moving on to question 2. I'll check my time here. Somebody left me a voicemail. Okay. So when you get your DSL or cable into your house, you have a contract, and some ISPs allow you to share, and some ISPs don't want you to share. So when you share and you're not allowed to share, maybe you're violating your contract with your service provider. Of course, for the user who's parked in his car outside your house, he's not involved in the contract, so he doesn't know what the situation is, and he doesn't have any kind of liability, but maybe you as the owner of the access point might have liability. One wonders then why they don't ship it to you closed if they want you to keep it closed. It's clearly because it saves them money to put the burden of securing your wireless access point on you, so there's potential contract stuff there. As far as I know, nobody's ever been sued for that. There was a case where Time Warner sued a company that made it their business to buy Time Warner cable access and then use that access and provide wireless to buildings. So this company was getting buildings to pay them. They paid Time Warner for one line, and then they would put in wireless throughout the whole building and get the building to pay them. And Time Warner sued them. But I haven't seen anything where anybody's sued end users for any providers have sued the end user or the wireless purchaser for that. Okay, what about liability for leaving your wireless open? Two things can happen. Obviously, if somebody comes by and uses your wireless for something improper and the trail of the investigation leads back to your house, you're going to have the unpleasant situation of being under suspicion when the police come and say, what's going on here? And the danger of that is that you'll be falsely accused or inconvenienced or that sort of thing. But then the question most people really have is, most people feel sort of confident they could talk their way out of things, whether they did it or didn't do it. But let's say you didn't do it and you talked your way out of it and they know it's not you, but somebody was victimized. Some other computer system down the road was victimized. What are you liable for that? And so the question is, basically the answer to that is that so far the law has never imposed liability on a company just for having an insecure system. We're seeing it more and more with data insecurity, as with all the ChoicePoint, LexisNexis, UC Berkeley, all these organizations that collect personal data and then people break in and steal that data. We're seeing some class action lawsuits for companies not having taken the proper steps to secure that data. And those cases may be the first ones in which we establish some kind of duty or responsibility to meet a certain level of security. But we haven't had cases that have basically decided that yet. And what the law requires for there to be liability is there has to be a duty, a responsibility that we legally impose upon you, and you have to have breached that duty. So we're kind of in the, is there a duty and what is that duty? What's the standard of care? What's your, not so much best practices, but what's the minimum that the law is going to require from you? And if you fall below that, then you pay. Okay. So there's been a couple little things that have kind of pushed that question of what the duty is forward. There are federal statutes which require you to keep data secure. For example, Gramm-Leach-Bliley requires you to keep certain financial data secure, and HIPAA, which is the Health Information Protection Privacy Act, which is for medical data. Portability, thank you, which is for health information. That has standards and says you have to keep that data secure as well. And then they've issued regulations which have some, I wouldn't call it specifics, and I have questions whether anybody in this audience would call it specific enough, but has some standards that a security policy or security protocol is supposed to meet to make sure this data doesn't get out. So we're moving towards a situation where there is a duty or a standard of care that's developing. But so far, nothing. Okay. Question 3. What's going on with the Patriot Act? I like to call it the USAPA instead of the Patriot Act because I think it's a little less propagandistic. But so the question is, how did the Patriot Act affect investigations for computer crimes, and what's going to happen with it? So there were two main ways that the Patriot Act made computer security investigations easier. One was the computer trespasser exception, and the other is increased wiretap authority. So to get a wiretap, you're not allowed to, as your law enforcement, you're not allowed to have a wiretap for just any old crime. You can only get a wiretap for a certain list of crimes, and they're kind of meant to be the most serious of crimes. Like, there's like RICO and drugs, and they sort of, what was the most serious is now sort of expanded. And it didn't used to be that computer crimes fit in under these types of crimes, which we call predicate offenses, for which you could get a court to authorize a wiretap. That's no longer true. Section 1030 is now a predicate offense that they can use wiretaps to investigate. But you wonder whether they even need to use wiretaps to investigate, because there's now this computer trespasser exception. And basically what it says is that if the service provider thinks that they've got somebody who's unauthorized on the system, and the government wants to do the monitoring, then the provider can bring the government in to monitor a trespasser who has no authority to be on the system. So if you are the victim of some kind of computer incident, you've got somebody who has access to your computers, you can call upon the government to come in and do monitoring in the hopes of catching this person, and it's much, much easier than it used to be prior to the Patriot Act. The question is, can you do the monitoring yourself? And there are a couple of other exceptions to the general rule is no intercepting somebody else's communications. And there are a couple of exceptions to those rules which may apply for service providers and may not. Let me see if we're going to do these soon. Yeah, we'll do these. I'm going to answer these questions, I think, pretty soon. But there are exceptions for service providers, and there are exceptions for for protecting the property of the service provider, and those may apply under certain circumstances. But generally, you can monitor in kind of the regular course of keeping up the system and that kind of thing. But you're generally not supposed to be able to monitor because you're investigating a crime, even when you're the service provider. And the reason for that, even though you're like, well, it's my system, and I've got some intruder here. The reason for that is often because you're not just impacting the privacy of the trespasser's communications. That trespasser is communicating with other people outside the system, third parties, who have their own privacy rights, and we try to be careful and respectful of those. So if you have that situation and you want to do the monitoring, it's worth talking to a lawyer to figure out exactly whether you fit well under one of the other exceptions to the general prohibition, so that you can do the monitoring yourself. I see another question. Does it apply? So the question is, does it only apply to ISPs or does it apply to private firms? It applies to everybody, basically. It applies to everybody. Okay. So where can I get more information about the Patriot Act and what's going on with it? Here's some websites. You can look at the Department of Justice website, and then some civil liberties groups that have been concerned about the Patriot Act. Obviously, there's a lot more to it than the stuff that I've discussed today, but I can tell you that the House just reauthorized some of the more controversial provisions of the Patriot Act, and the bill now goes to the Senate. So it's actually a pretty exciting time for Patriot Act. Whether you care one way or the other, it's a good time to kind of get involved and register your complaints or otherwise. So questions 4 and 6. Question about, which basically is a question I'm often asked about strike-back technology, and this goes to my comments about how broad the idea of access and unauthorized is, and what you're allowed to do with somebody else's computer system. And I think it's, since those are such broad things, and let's say if you're being attacked by some computer out on the network, you don't know whether that computer's a zombie or that one's really just being used by some other person or some other program to attack you. And you're not really sure how stable that is. So if you do something to it, you could totally bring it down, or you could, damage the information there or the system in some way. And so you're really looking at a problem where under the Computer Fraud and Abuse Act, it's a potential crime. There's nothing in the Computer Fraud and Abuse Act that says you've got any right to strike back against a computer that's attacking your systems. And since the risk of damage is it's so easy to cause damage, I have always thought that strike back, for example, is prohibited by the Computer Fraud and Abuse Act. There are some common law exceptions that you could argue if you were ever in this situation. Under the common law, there are defenses to crimes. One of the defenses is that you were acting in defense of yourself or other people. And one of the other offenses is that there was justification or necessity. And these defenses both kind of hinge on the question of proportionality. I mean, if a court believes that this is true, they hinge on the question of proportionality. You're only allowed to use as much force, just exactly as much force as is necessary to protect yourself, and no more. And I don't know whether a judge would even buy this as a theory of defense, but you want to, if you are ever in this kind of situation, you have to be careful that you're not going to take out some computer entirely, because that may be seen as being, overkill. And overkill is not going to let you fit in under these defenses. Okay, so now we're getting a little bit to these questions of monitoring in the context of the questions about honeypots. So I've done whole talks on honey-nets and honeypots and what the legal issues are there, but here you have some of the laws that apply, and I'm going to talk about just a few of these. Okay. As we've discussed, the real-time interception of the content of communications, like what you're saying in your email, is prohibited, and there's these exceptions. We've talked about the computer trespasser exception. There's other exceptions, too. There's consent of the party. So one of the things a lot of ISPs do is they have in their user agreement or something things where users say, I understand that my ISP may monitor me, or I understand that my employer may monitor me, or something like that. We have a provider exception, which is the service provider is allowed to monitor for the protection of the system. And then we have this exception for things being readily acceptable to the general public. Okay, so the consent exception, just to get a little more in-depth on this, it says that a party to the communication is allowed to intercept or can give consent to somebody else to intercept the communication. This is the federal law. Some state laws require that all parties to a communication know that something's going to be intercepted. And you may remember that this is how Linda Tripp got in trouble with Monica Lewinsky. She was allowed to intercept or record her phone calls under the federal law because she was a party to the communication, so it was okay. But Virginia is an all-party or dual-party consent state, and so she was in trouble under Virginia law because Monica didn't know that she was making these recordings. Maryland, thank you. So you want to be careful about what state you're in. California, where I practice, is also a dual-party consent state. The question then is whether banners actually help you, particularly when, will the intruder see the banners? Are banners going to be, if somebody doesn't hit the page that the banner's on, is that going to help you? And if you're a honeypot, maybe you don't want to have banners anyway. And then the question is, can the honeypot itself be a party that authorizes the communication? The answer is probably no. It's sort of an imperfect solution. But it may be something that ISPs or service providers can use if they get consent of the parties. The other major exception to this rule is the service provider exception. And while it has limited application to honeypots, it may have much broader application for service providers generally, and there hasn't been a lot of litigation as to the exact scope of this exception, but it does intend to empower the service provider to do what's necessary to protect its own rights and property with regards to the computer system. Okay, another thing people often ask about when dealing with honeypots is this question of whether it's entrapment. And the fundamental thing that you have to understand about entrapment is even if the government serves up to you on a platter the opportunity to do the crime, in order to get the defense of entrapment, you have to show that you weren't predisposed to do the crime already. So if the government says, here, do this crime, and you say, okay, then you're probably in trouble. You've got to say no 10 times before you can get close to being able to have the entrapment defense. It's an extremely difficult defense to mount. As a result, honeypots are never going to really be entrapping anybody. Since you're just providing the opportunity to do an offense is not entrapment. We talked already a little bit about the question of civil liability for insecurity when talking about the issue with wireless and what the standards are that are developing for setting some kind of duty of care. Okay. Seeing how far. Oh, we're doing really good. Okay, so logs as evidence. A lot of times technical people think you have to prove that the log hasn't been tampered with. That's actually almost the reverse is true. If you, as the proponent of the evidence, say this log was just made in the regular course of the computer's operation, then courts will almost certainly allow the logs in unless the opponent to the evidence can undermine the assertion of reliability to the extent that the court doesn't believe that the evidence is reliable at all anymore. If the court thinks there's some evidence that it's reliable and maybe it's not perfect, then what will generally happen is courts let the logs come in as evidence, and it's going to be up to the jury or the trier of fact to figure out how much weight they want to give to these logs. So I've had this problem in my cases where you have these logs which are not original at all. They're cut and pasted from the more complete set of logs. And the person will say, I just did a hunt and find, and I just, sort of grepped it and made it look like this, and I formatted it so it would look all nice. And I say, well, it's not original. You totally manipulated this data. And they'll say, yes, I manipulated it, but only so it looks nicer and substantively it's accurate. And the court will be like, it's good enough for me. So, yeah, you hate that when that happens. All right, reverse engineering. So this is really interesting and important. The question is do you have a right to reverse engineer, or are you allowed to do it? We know that reverse engineering provides us with this great social benefit. It lets us know whether a program or a machine does what it says it does. It helps us know whether something's going to be high quality anti-piracy protection. It lets us know how internet filtering programs work. It lets us know what spyware is really doing on our computers. It helps with interoperability so that you can develop new products that work with other products, which is really important for capitalism and competition. We like that. And it lets you find and study the ideas that are not intellectual property, unprotected ideas, methods, processes that are contained within either software or devices. Lets you learn how something works, which is really great and important. So courts have recognized this, and what they've said is that even if reverse engineering requires copying, for example, of software, we're going to allow it under fair use. It's allowed. So a lot of people think about that as having a right to reverse engineer, but more the way the law looks at it is that fair use is a defense to a claim of infringement, and you can say that I was infringing because I was reverse engineering, and then you'll be able to use that to protect yourself. So the kind of metaphor is this a right or is it a defense? Is it a sword or is it a shield? And often the way that the law looks at this is it's kind of a shield. So it's really, is it a right? Well, the law recognizes its social importance, but are you always allowed to do it? And there's two main forces which have amassed, which are endangering the ability to reverse engineer. One is the anti-circumvention provisions of the DMCA, and basically what this says is that you're not allowed to circumvent a technological measure which controls access to a copyrighted work. The statute's super complicated, and you can look at it yourself, but basically what it says is, if we've got something that's going to regulate technologically how you can use some piece of content that is copyright protected, you're not allowed to break that. And then, as with everything we do in the law, there's exceptions, and there's an exception for reverse engineering. So Congress recognizes that under some circumstances reverse engineering is important, and here is the exception for reverse engineering, which basically says it's okay and if you've reverse engineered and that's why you were circumventing this technological protection measure, that's okay, but you can only have reverse engineered for the purpose of interoperability. It's got to be necessary, not like it helps with interoperability, but it was necessary for interoperability with something that you totally independently created all your own and wasn't involving any kind of infringement or any kind of copying of any other sort or something like that. So, and under this narrow circumstance, reverse engineering is okay, but it's not okay in other circumstances where it's a circumvention. The other big legal attack on reverse engineering is EULAs and user license agreements or terms of service. And as with any right, even if we think of reverse engineering as being a right, you can contract away or give away your rights. When you join the CIA, you can contract away your First Amendment rights to write about what you saw and did in the CIA. The question then is, these contracts, when you have these mass market types of contracts that say, you're not allowed to reverse engineer this product, or you're not allowed to uninstall this spyware, or whatever the term of use that's in vogue now is, the question is, are those contracts enforceable? Is the law going to enforce them? And what the cases have generally said is that the law will enforce them, so long as the person who's entering into the contract had some opportunity to know that this was a term and agreed, either by clicking I agree or saying I agree or signing something or continuing to use the product after being given notice that this was part of the terms of use, we're going to enforce that term against the person. And this is a great idea which is built on this original conception of contract law as the meeting of two equal and independent minds and kind of the arm's length negotiation, and everybody is free to either accept the deal or turn away the deal, and so it's all okay. But it really does become a problem when you have these mass market licenses that are offered on a take it or leave it basis, where anybody who opts out, it's not like you have another choice, like I'll buy this product from somewhere else and I'll be able to reverse engineer it because I'm going to do something, make something that's interoperable that's going to be really cool. And then you can say, well, we're just not going to sell it to you because 99.5% of the population doesn't care. And we don't have to sell it to the part of the population that does want to reverse engineer it. And nobody's going to bargain for that right. And to the people who care about that right, we just won't sell to them. We don't need that share of the market. And so the problem is that these mass market licenses can basically take away the right to reverse engineer by contracting with all of us, which I include myself, who are not going to reverse engineer and who don't care, and just not selling to the few people who might actually do something with the product and make something interoperable and cool to go with it. So this EULA issue is really, I think it's, intellectual property's been really big with the internet in the past couple of years, and I think that contracts and EULAs are the next big question about, what we'll be free to do with our computers and with technology in the future. So.
Didn't they have something where, because you could opt out, that one of the EULAs was thrown out?
There have been so the question is, aren't there some cases where EULAs are thrown out? And their EULAs are thrown out usually for two reasons. One is, when they've been thrown out, one is because there wasn't really a contract, because the user didn't actually agree or wasn't shown the terms of the EULA before using the product or using the service. So those, I would say, are questions of formation. There wasn't really a meeting of the minds or a notice and acceptance of the terms. And another situation where EULAs have been knocked down is where the terms of the EULA are kind of explicitly against the public policy of the state. So California has refused to enforce certain EULA terms that involve arbitration agreements, because California provides its citizens with certain rights, and these EULAs take those rights away, and California said, well, with this arbitration stuff, we're not going to do it. Also with forum selection clauses, which is basically, you enter into this agreement with me, and you agree that if we have any dispute, we're going to hash it out in Florida, even though you live in Washington or something like that. And under some circumstances, these forum selection clauses have also been held not enforceable. And one of the things that we're looking at the school is what's kind of the underlying principle for the circumstances in which EULAs have been held unenforceable, and is that a theory or a principle that we can use to apply to other things that might be really important that we want to preserve and don't want to have EULAs be able to take away from everybody, like reverse engineering. But these have been very, very narrow circumstances in which EULAs have not been upheld, just on in those types of situations.
I thought there was something like, because everybody uses Windows, and they'd thrown out one of the EULAs for that type of thing, where everybody's using the software. You don't really have any opportunity to opt out, because there's not a significant alternative.
I'm not familiar with any cases in which, simply because it's a contract that's offered on a take it or leave it basis, and because it was drafted by the company, we sort of, in the law we call those adhesion contracts, and there are situations in which adhesion contracts or these sort of mass market contracts are not enforceable, but I'm not familiar with any cases in which they've been held unenforceable solely for that reason, that they're offered on a take it or leave it basis and you're not allowed to opt out. And that's one of the things that we need to look at, is the question of whether there's something with market share, for example, if it's, a big corporation and it's Windows and everybody uses it, or something like that, where there really is no choice, because they'll say you have a choice, you don't need to enter into the contract. So I'm not familiar with any cases where that alone has been the reason for not enforcing the contract. Okay, so now it's good we're asking questions because we're almost at that time. I do, good. Okay, good, we're almost at question time. So then the final question that I have is the question of when to talk to a lawyer. And I guess what I would say is, sort of in the lines of what I was saying before about how complicated this area of the law is, that if you feel like you understand all of this and you've got it totally down, you definitely need to talk to a lawyer, because it's not that easy. I mean, I've tried to, and I always do try to give people something that assimilates or approximates an answer, because I think that the answer, it depends, and I don't know what it depends on, is not very helpful. But, depending upon how risk adverse you are, whenever you're dealing with any of these issues that have to do with using or accessing or making some kind of contact with somebody else's computer or communications or stored files or that sort of thing, it's never a bad idea to run these questions by a friendly lawyer. So, it's sad, I think, that because this is kind of the opposite of what we're really going for in the law. I mean, the idea of the law is that it should be something, we're the citizens, we make the law, and the law governs us. It should be something that's relatively transparent, that, makes some basic intuitive sense to us, and is something that we can read and understand and correspond our behavior to, so that if we decide that we want to be on the right side of the law, we can, and if we decide we want to be on the wrong side of the law, we know. But that just hasn't happened. And, one explanation is the explanation I gave earlier, which is only half a joke, which is that this keeps us all in business. But I think there's another reason, which is really that the law here is developed really piecemeal. There's new situations that arise where there's no rules, and maybe we need rules. And then maybe we make up rules to fit that specific situation, but the rules apply to all this other stuff that we didn't anticipate yet. Or we take the old rules that were built for radio or for the telephone or something like that, and we try to extend them into these new situations. And they fit a little bit, but maybe they don't fit perfectly. And so we have this kind of mismatch between what we were trying to do before and what we're trying to do now, and it has these unintended consequences which create sometimes irrational or complicated effects. So it's only because the law develops more slowly and maybe in fits and starts, and so it's having a lot of trouble keeping up with technology. All right, so we have lots of time. How much time do we have for questions?
You've got 25 minutes before we say goodbye and go to cookies.
Okay, so we got 25 minutes till cookies, so now I can take, which is good, so we can take lots of questions, and I'll start with you.
You were speaking about monitoring communications, and you mentioned that federal law will require one party to consent, but many states have two-party or all-party consent laws. Packets usually don't go from one house to the next. They usually go from the states.
There's no cookies now, people.
Which states' laws affect your, if I'm in Utah?
I get it. Yeah. So this question is, well, federal law is single party, but your state is dual party, but packets don't go through one just from one state to the other. They go through all different states. So what law applies? And the law that applies will be the law of the party who's intercepted. You have to assume that it's going to be the law of the party that's intercepted. So there's two possibilities. It doesn't, because the law doesn't care about where the packets go. The law cares about the rights of the privacy rights of the people. So it's like, if I'm in a single party consent state and you're in a dual party consent state, then the question is, my state doesn't care if you don't know I'm monitoring you, but your state might. And if your state can get a hold of me, they might try to do that because I've injured the rights of somebody in their state. So that's what you have to assume, is that the person it's going to be the law of the person who's being monitored. So you want to adhere your conduct to whatever's the highest. So the state law that provides the highest protection, you want to go there. So I'm going to go to you because you had the question I'm not sure I answered before.
Okay. Provider exception. Do you think it would apply as well as to ISPs, but say corporations or small businesses or even home user networks for that matter?
It applies to anyone who provides services to the public.
But would the public be considered a corporation, for example, and their own internal networks? Could they monitor the networks from outside intruders under the provider exception?
So the question, can corporate monitor networks from outside intruders? And the answer, under the service provider exception, I think the answer to that would be yes. Yes. In the back. So the question is, are there going to be anything new in the Patriot Act, in the reauthorization that's just gone through? And I haven't studied it, but I haven't heard of anything that's new. Some of the big issues that they were fighting on were one of the sections of the Patriot Act that allows the government to get records from bookstores and libraries and stuff like that when they're doing foreign intelligence investigations. And I know that was part of the reauthorization bill. And that was one of the things that people were really most concerned about and were fighting a lot. But I'm not aware of whether there's anything new, but I wouldn't say that I'm an expert on that question. So it's a good question. I think that I'll take a look and see. So I'm going to take you as the last middle question, then I'm going over this way.
As far as being able to monitor vulnerability scan our own networks, how would that extend to organizations such as a located server at the internet?
So the question is, can I scan as a security person, can I scan systems that are co-located elsewhere under the service provider exception? And this is why I say that the scope of the exception is kind of undefined, because in the real world they're much more complicated than what the statute contemplated in the very beginning. But I think that an answer would be that if you own those boxes that are co-located elsewhere, and you're doing the scanning to protect your rights and property, that the service provider protection probably would apply, but it's definitely something where you want to sit down with a lawyer and explain the whole configuration and take a look at the text of the statute and see. I mean, you can always protect yourself with consent, right, if you can get consent from the users or that sort of thing, but I think that that's the type of situation where it would apply. But again, you want to get advice specific to your situation as opposed to my general gist of it. You know what I'm saying? Okay.
I'm from Michigan. Years ago, they passed a law. I've forgotten the name of it now, but basically the gist of it is that it is now illegal for you to hide the source of your traffic out onto a computer network. Many other states are adopting this law or similar laws. But when we look at what we all do for a living, all of us hide the original source out to the internet from where this traffic resides. I talked to the folks in the state of Michigan, and the response I got back was, well, we'll never go after you for that. That wasn't really the intent of the law. But I still look at it as it could move in that direction. What are your thoughts on it?
Yeah, so the questions about laws that say you can't hide the source of your traffic, and we're seeing those more and more, mostly because, or not mostly, but I think one of the big impetuses for those laws is anti-spam efforts and that kind of thing. And yet we know that there are all sorts of other reasons why people hide the source of their traffic, and it happens all the time. So you're supposed to be reassured when law enforcement says, oh, don't worry, we wouldn't go after you because we think that what you're doing is okay, but we'll go after somebody else who we think what they're doing is not okay. And this is exactly what's wrong with the way that laws are being made in this area, because the reason we have statutes is because we say, is so we know this is legal and this is illegal. And we allow prosecutors some discretion to make some choices within that context, but we don't want to have a world where basically everything's illegal, and then we let the prosecutors kind of pick and choose who they, whether they like the way you look or smell, or whether they don't like the way you look or smell. But then you get into these situations where discretion's being exercised on these grounds of that somebody looks like a criminal or a hacker, or somebody looks professional or reasonable or that kind of thing. So I think these laws are really dangerous. That's one of the problems I have with the computer crime statute. That statute's been used to sue people for robots, search tools, shopping bots, all sorts of things. And nobody's been prosecuted for that, because the government says, well, just trust us, we would never prosecute a company for making a shopping bot. But I don't have that kind of trust. What I want is the things that we think are legal to be legal, and the things that we think are illegal to be illegal, and not to have to depend upon a prosecutor to just pick and choose. I mean, as far as I'm concerned, that's not due process, that's fascism. So I think that that's a really serious problem, and is one of it happens because legislatures don't understand the way computers work or computer security or those sorts of things. So, in the back.
Going back to the concept of an open wireless network and who's responsible for whether or not you can jump on it, do you think there's any potential to put legal pressure on the vendors that make wireless devices to ship them secure? For example, if GM manufactures automobiles with multi-mechanisms that are so complex you have to be a mechanic to lock the car, I think there would be an outcry because people might not even know they could, let alone how to do it. So is there any way to apply pressure on like Linksys and Cisco and the other?
Right. So the question is, shouldn't we be put, or is there pressure on the vendors of wireless products to ship them secure as opposed to insecure? And you would think that there might be able to be something like that, because we have products liability type laws in other areas which have put pressure on companies to distribute their products in a way that's safe for their users. I mean, you use the question of the, car doors being locked, but there's, far more than that with cars of what you need to do in order to make it, basically safe for the average user. And, it may be that through these lawsuits that we see for data insecurity or something like that, that maybe somebody will develop a theory that says, well, it's not really the person who had the open wireless access point that did wrong. It's the company that distributes it insecure and in such a way that people don't know how to secure it that, caused the problem. And the reason why they don't do that, and one of the reasons why I have some real doubts as to whether that's ever going to actually happen, though I agree that the vendor is the party that is best able to shoulder the burden and cost of securing wireless. I think that just economically is clear, is that it is an economic burden. And they have to pay. Basically, the cost isn't so much the default. The cost is when it gets into the consumer's house and they're trying to set up their wireless network and they can't get on, it's the cost of having all those people in customer service who can answer the calls and help you actually get on. They ship it in the way that reduces their customer service costs the most, and to them, it's a great deal because they save this money on customer service, and any damage, any harm, any burden that comes from having the network be insecure falls upon the customer. They don't internalize that cost. So they have no economic incentive whatsoever. So we call this like a market failure. And when you have a market failure, if you want to change it, you've got to either have regulation or some kind of political pressure, or you want to do something to kind of change the economics of it in some way. And imposing civil liability is one way that might happen. Having customers demand better security is another way that might happen. One of the biggest customers that there is for computer technology is the government. And, one of the things that people who don't like regulation and believe in markets have said is something we could do to make security better, not just in the wireless context, but in all contexts, is for the government to start taking, the federal government and state governments too, to start taking security seriously as one of the factors that they use to decide what products they're going to buy. They're such a big customer that they can, put some kind of, that they can put pressure on vendors of all sorts in that direction. So.
There are a lot of security professionals here, security researchers. This gets back to the question of keeping your system secure. If I don't keep my system secure and someone breaks into it and then uses that to then attack another system, odds are because of the tool sets and code and whatever else I have on my system, I'm going to look like the guilty party.
Odds are.
To someone else who may have gotten in, who was able to circumvent what I have in place. So what recommendations do you have to security professionals and whatnot that are going to have, they're going to have the equivalent of the DEF CON t-shirt there sitting on their hard drive?
Right. So the question is, what if you have your system's compromised and you have some of those indicia that a prosecutor might think suggests that you were the perpetrator of the offense? What can you do in order to, make that clear? First of all, you've always got to have a friend you can pay to be an alibi, right? But if the paid lying alibi doesn't work, you want, there's often, I know this from Hacker Court, that it's like very hard to concoct a case, and evidence that's sort of airtight. So there's, you hope that there will always be evidence that shows that it wasn't you, whether it's a real alibi or whatever it is. But certainly, it's a risk, because when whether you encrypt your stuff or whatever it is, when they come along and they take a look at your computer system, if they see things there that make them think that it's you, and give them this idea that, well, you were certainly capable of it, then you're kind of in trouble. And that's one of the reasons why I think a lot of security people actually do spend time to secure their wireless and their networks and that sort of thing. But I mean, it's a tough question, because it's like, how do I look more innocent to the powers that be? And I think maybe we're all beyond that at this point. Yes.
One thing we're increasingly seeing is indications that hacking may occur when somebody literally down the street go hack a computer in China or Russia and come back to you and that's like a hacking trend. So far we have seen some very little chase such issues. So what worldwide effort is there going under this international
Okay, so this is a question about the sort of international aspects of the investigation and how the trouble that local authorities have investigating security incidents because they often are international. So there's been a couple of international initiatives recently. One is the European Cybercrime Treaty. The United States is a signatory to it. It has not been ratified by the Senate. I think that President Bush sent it to the Senate maybe like a year ago, but it hasn't been ratified, and it's not on the front burner. But many countries have signed it, including, I think, outside of the European Union, Australia, and I think Japan. And this is an effort to harmonize the laws across all the signatory states, so everybody has to make the same things illegal. And then everybody has to promise that they're going to help everybody else who's also a signatory to investigate the crimes by collecting evidence and information and that kind of thing. There's been some other initiatives that are more long-standing than that. There's some promises and collaborations between the G8 countries, and there's also independent agreements that we have with other countries, just in terms of treaties for mutual, it's called MLATs, mutual legal assistance treaties that will agree. But it has definitely been a problem because a lot of times, your local police officers aren't going to be familiar with the question of whether we have a MLAT with Ecuador, and if the information's over there, they may not be able to, they may have no idea like where they're going to start with that, and the crimes may not be something that's expensive enough or of interest in this particular case to the FBI. So there have been efforts to make it work by setting up these both sort of hotlines and also legal agreements between countries and multilateral treaties like the Cybercrime Treaty. I think the question remains to be seen how effective that will be in helping either local or federal authorities when they do need to do an investigation that involves collecting evidence internationally. In the back. So the question is, has one company ever sued another to sort of invalidate the terms of service or the EULA that says that you can't reverse engineer for incompatibility?
But actually, reverse engineer for incompatibility, if you haven't heard of cases like that,
It's interesting. I don't know whether there's ever been any cases like that, but there's a case that's pending now, which involves video games, and actually a lot of these reverse engineering cases, as you may recollect from that slide, took place in the context of video games. It's like video games are pushing the reverse engineering law forward, and the one that's really big and is going on now is Blizzard versus BNetD. And this is a multiplayer game, and some people reverse engineered this multiplayer game and created their own interoperable but different game server, which they thought worked better because it was faster and all of this stuff. And Blizzard decided that it would sue them, and one of the grounds they're suing them is that the Blizzard terms of use says you're not allowed to reverse engineer. So this is a case that's before does anybody know, is it the 7th Circuit? But you can find out information, I'm not sure, it might be before the 7th Circuit, but you can get more information about the case from the EFF website. EFF are some of the lawyers for BNetD, and that issue that you're talking about is one of the main issues. Now, I think that part of your question suggests why that's going to be a hard argument for BNetD to make, which is that a court, when I was talking earlier about how these are mass market licenses that are take it and leave it, or leave it and you just kind of don't have any other choice. There's two things about the Blizzard case which I think make this argument less likely to succeed. One is Blizzard's not a big monopoly, so it's not like you have to play the Blizzard game. You can play other multiplayer games if you want. And the other thing is that I think a court might feel a lot more strongly about interoperability in a case other than a case that involves the right to play your video games faster and without ads, or something like that. So I think in a lot of ways the best cases that will deal with this question of whether a company can, prohibit reverse engineering or benchmarking or criticizing the product or something like that, in EULAS will involve a company that has a lot of market power, where there really is sort of a take it or leave it, and customers really don't have practically another choice, and will involve something that's like speech or something that courts that courts will feel like maybe a little more in tune with than creating a competing game console. So, but I think if you look at that website, if you look at the EFF page on that case, you'll find out a lot more about it, and we can talk about it then. You can. I only have one more question. Okay, you can. I'm not sure I'm going to answer your question because I might want to take two, but I'll let you ask it.
What about those cases, rare cases where in some situations they will allow some reverse engineering of components so that you can swap in other components? So with those cases, why support that kind of action?
So his questions about the printer cases. In the printer cases that I'm familiar with, they didn't involve EULA questions. They were anti-circumvention questions, and there they allowed it, but it didn't involve the question of the EULA, and the contract makes a big difference. I'm still going to take two questions. I'm going to take you, and then this gentleman in the yellow shirt. So, yes.
Jack, from what you're saying, strike back applied to known after standards. What are your thoughts on, say, large group of individuals send off a single legal email, and the cumulative effect is to create a denial service?
So he's asking about strike back on spammers, like where each person only sends one email, but they all send it to the same thing, sort of in concert. I'm going to say it's conspiracy, and it's probably bad. Okay. See, that was quick, so that's why I can take two.
I have a question about the European data privacy issue. How do American corporate laws apply to American companies in Europe? I don't know if we are not supposed to look into data or investigate into data for employees who are in Europe, but they work for an American company. So how does it, are we allowed to, is it legal or is it illegal, look into their data for investigative work for company legal purposes?
Right. So the question is, do American laws apply to American companies overseas? And I guess similarly, do American laws apply to foreign companies operating here? And do American laws apply to foreign companies who operate overseas but have American customers? And I think that the safest answer I can give you about that is that if American law can apply, we will apply it. So if you are a foreign company doing business here, regardless of where your American company with its principal place of incorporation in the United States doing business overseas, even like it's going to apply. Anytime, if you are American citizen, American company, or you do business with Americans, the United States will try to apply its law to you. And it's not that common that courts say American law is not going to apply. So, there may be special circumstances, but generally you've got, you're safest. If America can exercise jurisdiction over you, you need, that's what's going to happen. Yes. So you've got, because the corporate headquarters are subject to the law here.
My question was actually an American company located in Europe. So are we allowed, is it legal to investigate data for employees who work for American companies in Europe?
The safe harbor.
Yeah, the safe harbor. The safe harbor is for you've got the European data privacy laws, and there's a safe harbor for American companies doing business with Europe. Then you've got the American laws, and then do those laws apply to companies that are European companies? But if you're an American company, I'm still thinking that the American laws are going to apply. Okay.
Pay taxes, you catch.
And everybody pays taxes.
I'm saying if you pay taxes, then you're probably obligated to those laws.
Yes, that's probably almost definitely true. Okay, so thank you very much. And if you have other questions, I'll be around and you can come and ask me.